What's up, everybody? So, had somebody reach out to me on YouTube and ask me about what's supposed to happen when you claim your ADHD accommodations or you claim accommodations at work. Because accommodations are probably not even being fulfilled in schools, but they are definitely not being fulfilled in the workplace. So, these are the recommendations that I would give you. I'm not going to go into much background about what happened with me and how I came to understand this stuff. So, get the employee handbook and look at the procedure in the employee handbook regarding what you're supposed to do as far as notifying. Second, I would go to your doctor and I would get a letter specifically noting that the accommodation, what you're asking for is part of your diagnosis and your accommodations, but it's also specific to your workplace. That's important. And then I would either submit it to my first line supervisor or I would submit it to HR. Now, depending on the organization that you work in, you're going to get a couple responses. If you're already in conflict with them, they already hate you. So because they hate you, they're probably going to retaliate against you. They're probably going to ignore it. They're not going to acknowledge it. And they're going to come at you and try and come up with anything they can do to get you fired or terminate you. If you work for a good organization that knows what they're doing, they're not going to care. They'll just be like, whatever, fine, no big deal, which probably means you didn't need the accommodations anyways because things were functioning like normal. And that's rare. So whoever you take it to, give them a proper amount of days. And then, I don't know, 5, 10, I usually give 10 days. When I notify people. Lawsuits are 20 days. And you have to remember that you are actually initiating an investigation into the organization and you are gathering an investigatory evidence that will be used against them in a federal investigation and further litigation. So you must approach it like this. They don't, and they don't know what they're doing, and they don't even know their rules. They don't know their policies and procedures. Most HR directors were told that they could get sued. They were just never told that they will get sued. And until people figure out how to actually set them up to display all their bad behavior, they won't get sued. And it's a hit or miss. So take it to them. You give them 5 or 10 days. I would say 10 days to respond and notify you, blah, 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 blah. Of what they're going to do. And then if they don't respond, I would follow up with them and I would give them another chance to respond. And I would give them another 5 days or half of what you gave them before. If they don't respond then, I would escalate. So I would start moving my way through their system all the way to the top. Now, when you escalate, if you have to do this, make sure that you take everyone with you. So if you went to the HR director first and she didn't, then she's in the bucket. She's on every single email from that point forward. If you take it to your supervisor and whatever supervisor you go above that, you put them on the email too. They are personally liable for restitution legally, but no one ever puts them all in a bucket. So you got to collect them together. I think by the time I was done with my employer, I had 19 people, including the elected representatives. So, and they're all subject to personal restitution. That's the way the law works. And they're all in the bucket. They all knew, they just ignored it. So that's pretty much how you do it. Now, from that point forward, it's going to be about notification and declaration. You've already declared your accommodations legally. So now any interaction you have, those accommodations are at play. If you have any verbal conversations where it's inappropriate or you feel that you're being attacked or you feel that they are trying to maneuver, don't get angry and don't get frustrated. I know it's really hard to control your emotions. Become very inquisitive to them. In other words, whatever verbal or telephone conversations you have, send them an email with a summary of the conversation and ask them questions about the details of what they said to you. Okay? Because if they're retaliating, they're going to try and come up with whatever they can. They're going to try and accuse you of things. They're going to try and put you in investigations. They're just going to make it up. They're not going to follow the rules. If you're government and you're under a union contract, that's a breach of contract. They're going to not give you due process, and it's all going to be accusatory. They're not going to do the proper investigations that are according to their policies, and they're just going to keep going. So the question is going to become, they're looking for submission and compliance, and you're not to have any rights, and you're not to have any say. You're looking to be treated like a human being with dignity and respect. The problem is, laws aren't made for us to understand law. Law is made for us to apply when someone transgresses us. That's why laws are built. That's what they're built for. They're built for the people who have had unjust things done to them to get justice. That's what law is. So, but you have to declare it and you have to notify. At that point in time, I would tell you to just try to be calm and try to be patient and ask a lot of questions. Send them lists of questions, everything they're doing. Anyone engages you inappropriately, any accusations, any hostility, don't get angry and don't respond. Simply send them an email summarizing and asking questions. They're not going to keep notes, and these are contemporaneous notes, but this is really evidence. This is where the evidence comes from. And it comes from notification. When someone notifies you, just like in a legal case, and this is what you're conducting, when someone notifies you, you have three options. You can accept, defend, or disregard. This is how the court works. When you get a lawsuit filed on you, you have 20 days to respond. If you don't respond within 20 days, that's it. That's it. The case is done. So it's summary judgment. All I have to do is file a summary judgment, go into a hearing, and they're going to get everything they asked for because you never responded. So you have three options. When someone brings a petition to you, or they bring a complaint to you, or they bring notification to you, you can accept. In other words, I accept whatever is on this. I defend it. In other words, I'm going to rebuttal it, and I'm going to explain that was not my position and whatever else. I'm not going to become accusatory. I'm simply going to explain my actions and my position. Or you can disregard. Ignoring is the worst, because the person who petitioned you, if you ignore them, then everything that they said in those documents is absolutely true. So when I was sending documents to 19 people, they were all told to ignore by the lawyer. The problem is, what they didn't know is that ignoring is an admission of guilt in a court of law. So everything that they ignored on, every question that they never answered, everything that they ignored, every summary that they never answered, is actually proof in evidentiary. And they can't explain it because they never actually responded, and they have a responsibility to respond. So that's the way it works. Let me know if you have any more questions or you need something clarified. And good luck. It's a road.